This is Chapter 2, Medical Ethics, Law and Compliance for Medical Office Procedures. And these are the learning outcomes that you'll be able to understand by the end of this chapter. Depending on when you have this course, you may already be in a law and ethics class, or you will be in one, or you've already taken one. So some of these things may be a review. Some of these things you're going to see in that class if you haven't taken it already. And some things you may be like learning at the same time as this course. So you're going to see these again in a completely, in a full course. So this is a much shortened version of all those things. So you're going to learn more in that law and ethics course. Here are some of the key terms. There's quite a few for this one, but you may be familiar with some of them by now. So the first thing that we talk about is medical ethics and what that kind of means. So ethics is the standards of conduct that grow out of one's understanding of right and wrong. So a lot of times ethics are legal, but it's up to you to decide whether or not you feel it's ethical or not. So kind of like what you feel about certain situations. Hippocrates, the Greek physician who lived during the 4th and 5th centuries, he was considered to be the father of medicine, made the first statement of principles governing the conduct of physicians. So physicians now take a Hippocratic oath, which is one of the things, which if you've ever seen the symbol with the staff and the snake around it, that's because their physicians are agreeing to follow that Hippocratic oath. So this has been around for quite some time. As for your position, there are certain ethics that are developed by the American Medical Association, by AMA, by AHIMA, by AAPC. The outline that I have for this chapter on your modules includes those ones that are not listed here, but every credentialing body, every association has their own form of ethics. And if you ever go to get a certification from any of them, you're agreeing to follow those ethics. So AMA says that you agree to practice standards of patient care, respect patients' rights, treat patients with compassion, and safeguard patient confidences. American Association of Medical Assistants has their own code of ethics and creed, which kind of follows some of the same things. Treat all patients with respect, maintain confidentiality, conduct professional activities in a manner that honors the profession, improve knowledge and skills, and contribute to the community. Bioethics deals with the ethics of medical treatment and technologies, processes, and scarcity of resources. This includes things like whether or not we should clone, what are the rights of the human fetus, genetic engineering, what should we do with organ donations, and what should we do with situations where who chooses how organs are dispersed, when is it acceptable to remove patients from life support. So what do we consider? Physically, we consider someone to have no brain life, but bioethics discusses what if that is a correct interpretation, or should this person be on life support because they're able to handle certain things. Do individuals who have the right to produce a child for sole purpose of providing cells for another individual? Should providers have the right to refuse healthcare for morbidly obese patients? And like things like how we take care of people towards the end of life. All of those fall under the bioethics. Etiquette is defined as those behaviors and customs that are standards for what is considered to be good manners. Code of ethics specifies standards of capable patient care, and etiquette is a broad term for behaviors that mark a courteous treatment of others. There's a scenario in your textbook on page 45 that kind of goes over some etiquette situations with that. Medical law is the other half of this. So law is a set of rules made and enforced by a recognized authority. So it's less obscure than our ethics. It doesn't necessarily mean that you agree with some of the laws that are in place, but they are more defined. So, medical law regulates the right to practice and the granting of various licenses and certifications. Each state governs the practice of medicine within its borders through laws known as medical practice acts. So, this is why if certain licensures you only are available to have in certain states, and if you go to another state, you have to get a new licensure, or some places will just accept like a crossing. Accept a fee to get that license. So being aware of what those things are. So the Medical Practice Acts define medical practice, explain who must be licensed to give healthcare, set rules for obtaining a license and renewal of license, state the duties imposed by those who have a license, cover grounds from which a license can be revoked, and list statutory reports that must be sent to the government. So they handle licensing, certified specialization, and also narcotics registration. So narcotics registration are those who will have anyone who has to disperse drugs for any scheduled drugs. So the more narcotics, they have to actually have a DEA pad, and some states want you to have they won't allow narcotics to be given narcotic drugs to be given electronically. So you would actually still have to write them out even if they're using e-prescribing. Physician's practice. This section talks about contracts and consents. So a contract is an agreement between the patients and the physicians. There's different forms of consent that the office is going to use. There is implied consent, which applies to routine treatment only. So for instance, you're telling a patient that you're going to draw their blood, and they pull up their sleeve so that way you can draw that blood. That's kind of an implied consent. They're agreeing to let you do that. Express consent is for more complicated procedures. These ones need to be, they can do it written, they can do it orally. We prefer it written because, as you're going to learn, if it's not documented, it didn't happen. So having that oral written form is a much more concrete one. An informed consent is another one that's not listed here. That one is our more written one. It is whenever a physician explains something. So, for instance, going into a surgery, letting them know what the risks, the benefits, what will happen if we don't do anything, what will happen if we do this, what are some other treatment options, and having the patient understand it. And that informed consent needs to be in a way that the patient can understand. So making sure that it's to their level. There's an example of an informed consent form on page 48 in your textbook. And whenever we have these types of consents, one thing that we need to consider is whether or not they are legally competent, meaning do they have the mental capacity to understand what you're talking about? So a dementia patient maybe wouldn't be considered to be legally incompetent. Um, some of our MRDD patients wouldn't be, so they would need to have someone who either is their power of attorney or their proxy or something to sign for them instead. Minors, it kind of depends on the situation with the minor. If they are 14 or older, they're allowed to make some choices without having the parents' consent, especially when it comes to any type of sexual acts or testing for HIV or STDs. Um, but when it comes to an emancipated minor, we treat them as though they are an adult. So in most states, that's 18 years old. So they're able, so even though they're younger than 18, they have been given independence by the court or from their parents or guardians. So they're allowed to make those decisions as though they are an adult. Advanced directives are something that we talk about very frequently with our patients. There's different types of advanced directives. This can include a DNR, which is a do not resuscitate, living wills, who's the proxy, who is the power of attorney. All those fall under the advanced directives. So, advanced directives are legal documents stating that the patient wishes for medical care in the event that they're not able to make those decisions. A lot of offices like to have some sort of advanced directives for all their patients, regardless of how old or young they are. Physician's orders for life-sustaining treatment. This is a multi-section medical order form that allows patients to choose the level of life-sustaining services signed by both the patient and the physician. Can also be referred to as the medical orders for life-sustaining a treatment, medical orders for scope of treatment, and physician orders for scope of treatment. So there's just different terms that you may come across that mean the same thing. Medical liability and communications. Liability means legal responsibility. In many areas of life, people are liable or legally responsible for their actions and their consequences. So, when we talk about it with the medical office, physicians have the liability and in their roles and providers of healthcare and as owners of a medical practice. They fall under the doctrine of the Latin term respondeat superior, which means let the master answer. So they're responsible not only for what their actions are, but also their employees' actions, as long as they are acting within their scope of practice. So physicians are responsible for their actions of their staff. And they're also responsible for the safety of their employees. So making sure that there's an office policy and procedures manual, what to do if there's any type of accident, making sure that people handle discarded waste and hazardous materials correctly, making it a safe and secure facility for the patient, for the employees, and then also for the patients. So the premises also needs to be safe. So ensuring protection from injury, theft, and fire. Malpractice suits. You may have heard this, or you've seen commercials on TV if you've been hurt in an accident or been injured from some type of surgery. If you had a mesh implant, you can qualify for this malpractice suit. This is resulting from an improper care or treatment by a physician, hospital, or other provider as a result of carelessness, neglect, lack of professional skill, or disregard for established rules or procedures. So there's a very broad term for malpractice. A lot of facilities will actually make you have some sort of malpractice insurance. So that way, then, if there were ever any case, it helps to protect you and the office. For the office itself, We have situations where we can terminate patients, but we always want to make sure that we do it correctly. So termination can be whenever a physician and a patient choose to no longer see each other. It can be from the patient's side or from the physician's side. Kind of the agreement doesn't necessarily need to be in writing. It could be one of those express consents like we spoke about. Basically, once the physician agrees to see the patient and the patient comes to the office, the consent is there, whether it's written or not. A lot of times during that first visit, we also have them sign a policy situation, which lets them know like what the physician requires and what the patient's responsibilities are. But at times, a physician can choose to terminate or end a physician-patient relationship because the patient does not follow treatment instructions or because the patient has stated that they intend to seek care from another physician. So it can be because they want like more than just a second opinion because they're not exactly choosing to leave somewhere else. But whenever we get like a release of information form saying that someone else is going to see another doctor, then we're going to terminate things with the patient and allow that other doctor to take everything over. If the patient is unreasonably demanding or threaten the provider or any member of the medical team, it may be necessary to discontinue providing medical care to the patient as well. Other reasons could be because the patient relocating, retirement of a physician, or non-payment of charges. So termination can be both good or bad. It could just be because we don't patients moving, and we consider it to be termination. Or maybe the physician in the office is retiring or switching companies, which happens pretty frequently. In order to prevent medical abandonment, we have to let them know in a reasonable amount of time that we are terminating them. So regardless of whether it's because of them, we're terminating them because they didn't follow the physician's orders or they no-showed 3 times and policy for the office says that we no longer can see them. We always need to let them know in writing that they are being terminated and give them a reasonable amount of time to find another physician. If it's because like the physician's leaving, we usually for any of the other cases, we give them like a list of other potential physicians that they're able to see. And keeping a good track of history, having good documentation will help prove that the physician didn't abandon a patient if there's ever a situation. Assault and battery. Clear threat of injury to another is called assault, while any bodily contact without permission is called battery. In medical law, battery is interpreted to include surgical and medical procedures performed without the patient's consent, or procedures that go beyond the degree of consent that was given. Fraud and abuse. Fraud is an intentional, dishonest practice that deprives others of their rights. It's often committed by a medical professional to gain monetary payment and other benefits to which they would otherwise not be entitled. So some different examples of fraud would be making false statements to a patient about the benefits of a particular drug or treatment, falsifying diplomas or licenses, submitting false or duplicate claims for a payment of the federal government or an insurance company. Litigation is the bringing of lawsuits against the physician. Many lawsuits can arise from civil law. And your textbook does give some steps for the litigation process. As well as the physician's response to litigation. And those are on page 55 in your textbook. The Good Samaritan Act is designed to protect people who render care to an injured person from liability. So, for instance, you go to help someone who is injured in a car accident. And as you're pulling them out, because the car is burning, you hurt them. So the Good Samaritan Act protects you from harming them while trying to also save them. As long as you go within your scope of practice. So, like on TV, whenever people make a trach out of cellophane and straw, that would not fall under your scope of practice. So that would not qualify for the Good Samaritan Act. But giving someone CPR and breaking ribs because you gave them CPR would be covered under Good Samaritan Act as long as you're CPR certified. One of the things with the Good Samaritan Act is kind of once you step in, you kind of need to stay until it's either not safe for you or until EMTs arrive. But at the same time, it's also expected of you to do something. The False Claims Act is a major legislative weapon in the fight against fraud because it protects whistleblowers against retaliation. So if you ever come across something that is fraud or abuse in the office, the False Claims Act would protect you from the office coming after you later on. And Stark Law, anti-kickback laws, prevents physicians from making any type of patient referrals to an entity that provides designated health service and receives payment from a federal health program if the physician has a financial relationship with the provider. So not allowing someone to make money because you referred them, or not having any types of dealings that would resolve in money coming in. Patient's Bill of Rights. In 1997, there was the original version of Bill of Rights that was passed by Congress. The goal was to create and increase, strengthen consumers' confidence in the healthcare system, establish a stronger foundation to which to build physician-patient relationships, and emphasize the patient's right to receive quality care, and make patients more responsible. There's a list of all the patient's rights on page 58 in your textbook. It has the original patient's rights and then the additional ones that were made in 2010. So you should be familiar with some of those, or at least recognize them if you come across them. Medical communications is access to information. All information a patient gives to a physician is considered to be confidential. And administrative medical assistants who process physicians' correspondence and work with patients' records are authorized to read this information, but no information may be conveyed to anyone outside of the practice. So all information a patient gives is confidential. Patients must provide a general consent to sharing of information for purposes of carrying out treatment, submitting insurance claims, known as the final privacy rule. We usually have them fill out a release of information form or an ROI, so that way we're able to have that correspondence. And it must also provide a written authorization for specific items that are not covered by the general consent. The release of information form needs to have be in plain English or in the patient's preferred mode of communication, and include a description of information that should be used or disclosed, patient's full name or date of birth, name of other specific identification of the persons or entity authorized to receive it, description of purpose for each requested use or disclosure, an expiration date, signature of an individual, the date the form was signed, and a statement that the patient may revoke the release of information. And there's an example of a release of information form on page 60 in your textbook. HIPAA is a term that you're going to hear very frequently as you go throughout this program. HIPAA is the Health Insurance Portability and Accountability Act, and it has several different parts that play with it. There's three different ones. HIPAA Electronic Transaction Code Set Standards Requirements. This is having the normalization between codes. So, national standards for electronic formats and data content are the foundation of this requirement, and HIPAA requires every provider who does business electronically to use the same healthcare transaction code sets identifiers. So, whenever you talk about things like using the same codes, using the same terminology, all of that falls under the transaction code set standards. Privacy requirements limit the release of patient-protected health information without the patient's knowledge and consent beyond what's required for patient care. And security requirements outline the maximum administrative, technical, and physical safeguards required to prevent an unauthorized access to protected healthcare information. They use these to help safeguard confidential health information during the electronic interchange of healthcare transactions. So everyone who has to comply includes not only the people who work in the office, but like everyone that interacts with the office. So covered entities is one of them. There are three categories for covered entities, and these are providers, health plans, healthcare clearinghouses. So a healthcare provider would include any person or organization that furnishes bills or paid for healthcare in the normal course of business. Providers include physicians, hospitals, pharmacies, nursing homes, durable medical equipment suppliers, dentists, optometrists, and chiropractors. Health plans, so all the insurance companies. Individual or group plan that provides or pays for the cost of medical care. They can be employee welfare benefit plans, healthcare plans, or government plans. Healthcare clearinghouses. These are companies that translate or facilitate translation of electronic transactions between providers of healthcare and the healthcare plans. They are kind of the middleman between, or go between insurance companies and the office. They help to facilitate claims faster because they would recognize things, but they need to follow the same HIPAA standards as if working for the office. And business associates are people who are third parties. So, for instance, if the facility has someone do their billing and coding for them, they would still need to comply with all HIPAA security rules and comply with breach notification requirements. HIPAA standard transactions. These are standards that apply to exchanges for the most common business communications between providers and payers, generally expanding the amount of health information that is exchanged. They can be electronic or by paper. And there's a list of the most common ones on page 64 in your textbook. Standard code sets are using the correct code books. Code set is any group of codes for encoding data elements such as terms, medical concepts, medical diagnosis codes, or medical procedure codes. And a list of those is also on page 64 in your textbook. We're also going to be talking about them in future chapters. The HIPAA privacy rule is intended to give patients more control over their own health information, set boundaries on the use and release of health records, establish appropriate safeguards that healthcare providers and others must achieve to protect the privacy of health information, hold violators accountable with civil and criminal penalties that can be imposed if they violate the patient's privacy rights, strike a balance between public responsibility supports disclosure of some forms of data, such as to protect public health. Protected health information is the core of the privacy rule. It's the protection, use, and disclosure of protected health information. It means something that is identifiable health information that is transmitted or maintained by electronic or other media. So any type of protected health information, whether it be paper or electronic, we make sure that it remains secure. And what we consider that to be anything identifiable is typically like the patient's demographics, their name, social security number, address, etc. Even some of the ways that we word something about a patient would be considered to be protected health information. Along with this is any type of data that they give us regarding payment, checking accounts, anything financial would fall under this protected health information. Patient rights. Patients have the ability or right to access, copy, and inspect their health information at any time. This was one of the reasons why we created a patient portal for them, so that way they could access all those without necessarily having to come in and get access to it. The right to request an amendment to their healthcare information. So if they notice that there was a diagnosis that they don't feel should be there, they can ask them to remove it. And then if the physician chooses for it to remain, they have to explain why it's there. The right to obtain an accounting of certain disclosures of their health information. So asking what information was released and who it was released to. The right to alternative means of receiving communications from providers, and the right to complain about alleged violations of the regulation and providers' own information policies. Exceptions to the privacy rule. So these would be times where we don't need to have anything necessarily in writing from the patient. This would be a release under court order, workers' compensation cases, statutory reports, HIV and AIDS research data, and if it's de-identified health information. So all of that protected health information has been removed or scrubbed, as we sometimes call it. It would mean like it's either blacked out, redacted. Maybe we're just using statistics and they've basically broken it down into like just graphs and tables, numbers. So anything, as long as it's not identifying the patient, we can use those under the privacy rule. HIPAA security rule specifies how covered entities must secure protected health information on computer networks, internet, extranets, etc. So any electronic media that we use. And this includes the making sure that we're using passwords, making sure that the office is secure, making sure that things are locked, changing passwords frequently. All of those would fall under the security rule. HIPAA national identifiers are identifiers that are required. Providers have their own. It's called an EIN, Employer Identification Number. This is released by the IRS. National Provider Identifier, NPI, is for the physician. So instead of using their social security numbers, they can use a national provider identifier instead, so that way their information remains secure. Health plan identifiers, this would be the insurance plan number. And patient identifiers are currently not being used because of public concern over privacy. A patient identifier standard has not yet been adopted. So some facilities may use something like their insurance number, make up a number, or they may not have one at all. Medical compliance plans and safeguards against litigation. So specific risk areas and practices the medical compliance plan address are coding and billing situations, reasonable and necessary services, documentation issues, improper inducements of kickback and self-referrals, and HIPAA compliance. There's 7 basic elements for a compliance plan, and these include written policies and procedures, designation of a chief compliance officer, training and education programs, an effective line of communication, auditing and monitoring, well-publicized disciplinary directives, and prompt corrective action for detected offenses. The role that you would take in compliance includes accurate data entry, accurate documentation, timely filing and storing of electronic and hard copy records, and prompt reporting of errors or constant or fraudulent conduct. And here are the learning outcomes and key concepts that you should be familiar with from the chapter. And they're broken down by those learning objectives that we spoke about at the beginning. And if you don't know any of these key concepts as you see them, make sure you go back and review that section. I also have an outline on Canvas that kind of goes over some of these same things and some in a little bit more detail than what's in this PowerPoint. So also check out that outline. And the last thing are these true and false questions. If you want to kind of check your understanding and want to answer any of these true and false questions, you can send them to me in an email, and I will let you know whether or not you got them correct or not. And it's a good way to kind of check and see if you met those learning objectives or what area you need to focus on as you continue on doing your work.